Welcome back to Executed Justice for Justin Root. Today, we're going to read through the family's civil suit that they brought against not only the city of Boston, but all of the officers that were involved in the shooting. As you know, there were, I want to say, five Boston police officers, one Massachusetts state trooper, and then also the city of Boston. They are suing. So let's just jump right in. Please hit that like button and let's go. So we did talk about this in the timeline episode. There were a lot of things that where this got like dismissed or things were, things have not progressed all the way for some kind of a resolution at this time. They're still waiting for some kind of resolution for all of this. The family, in my opinion, needs some kind of justice for what happened. And no one, as we've gone through, has taken accountability for it. And this came, so February of 2020 is when the incident happened. And now by August, the family is suing. They've already heard from DA Michael Morrissey stating, oh, we didn't do anything wrong, by the way. And so as you could probably tell, they're coming from a place of frustration, and now things are probably starting to unravel. The truth, bits and pieces are starting to come out. So let's get started. This is please hit the like button too if you haven't already. This is Jennifer Root Bannon, the sister of Justin Root, as the special personal representative of the estate of Justin Root, is the plaintiff, versus Boston police officers David Godin, Joseph McMenamy, Leroy Fernandez, Brenda Figueroa, and Corey Thomas, Massachusetts State Trooper Paul Keneally, and the City of Boston, Massachusetts. This is a complaint and demand for a jury trial. So we're going to skip some parts here. I'm going to briefly go through this and then we're going to skip a little bit and then get more into it. But all right, so the preliminary statement on February 7th, 2025, Boston police officers David Godin, Joseph McMenamy, Leroy Fernandez, Brenda Figueroa, and Corey Thomas, and one Massachusetts state trooper, Paul Keneally, together shot and killed Justin Root while he was on the ground, unarmed, seriously injured, and desperately struggling to breathe. We do know this from an eyewitness. This is not speculation. Mr. Root did not flee. He did not point or brandish a weapon of any kind. He made no threatening or overt act towards the individual defendants or anyone else. In sum, he undeniably posed no immediate threat to harm anyone. But within seconds of charging toward a bleeding and helpless Root, the individual defendants, without warning, collectively fired at least 31 rounds into him in a span of approximately 3 seconds. Just imagine that. And he's already lying there injured. The individual defendants undeniably used unnecessary, gratuitous, and disproportionate force in effecting the seizure of Mr. Root in violation of his constitutional rights. An indication of the individual defendant's callous disregard for Mr. Root's life can be found in video footage recorded immediately after the shooting. That footage demonstrates that not only did these officers fail to render aid to Mr. Root following the shooting, but some of them spent those moments congratulating each other. Yeah, that's seriously what they did. Disgusting. They were boasting and discussing how to cover up their actions. This is all caught on film. Their statements included the following: yeah, I killed that MFer. I emptied my magazine on him. Just shut your effing mouth, somebody else said. And then another one said, you got a union rep coming? And another one said, I won't talk. Another one says, I got to get out of here. Wow. Based upon the conduct as described in greater detail below, the estate of Justin Root has brought the present action against the individual defendants and the city of Boston for their violation of Mr. Root's rights under the 4th and 15th Amendments of the United States Constitution, the Massachusetts Declaration of Rights, and Massachusetts common law. By this action, the estate seeks to shed light on precisely what transpired on February 7th, 2020, to hold the defendants accountable for their wrongful conduct, since no one else will hold them accountable, and to ensure that appropriate remedial measures are taken by the Boston Police Department and the City of Boston to prevent similar tragic killings in the future. So this other section talks about jurisdiction, just says that they have jurisdiction. This other section talks about who all the parties are, which we've gone over in length, and we just listed them before. Basically, these are saying that they were employed as whatever Boston police officer, and they were acting in their scope of employment for their duty. That's what those facts are saying there. Okay, moving on to the background of the case. Mr. Root was born in 1979 and was raised in Boston, Brookline, and Ashland, Massachusetts. In February 2020, he resided at 13 Catbird Court, Mattapan, Massachusetts. When he was 20 years old, he was diagnosed with both bipolar disorder and schizoaffective disorder, two chronic mental health conditions. Since approximately 2010, Mr. Root was treated for his psychiatric illness at the Massachusetts Mental Health Center located at 75 Fenwood Road, adjacent to the Brigham and Women's Hospital in Boston. That is where the first incident took place in this case. Among the problems caused by Mr. Root's psychiatric disability were delusions that he was a law enforcement officer. In fact, Mr. Root had previous interactions with the Boston Police Department arising from such delusions. We actually talked about that. They wrote it in their reports that they knew this man, this person, Mr. Root, to have a history of thinking that he was law enforcement. They knew him. They knew he had mental health disabilities, and they inst- maybe they didn't know him coming up upon him immediately, like Officer Godin didn't know him immediately, but he was known in Boston PD. It's known that right across the street there's this mental health facility that treats patients. So it's feasible that you might want to take precaution around the hospital and that area when dealing with anyone. You might just want to take precaution instead of what they did, which was they just walked right up to him and started shooting him. But, anyways, so as a result, the Boston Police Department knew about Mr. Root's mental health struggles, as I was saying, that he previously had been hospitalized and that he sometimes carried a clear plastic paintball pistol and or a BB pistol gun pistol. On March 26, 2019, Mr. Root drove into the parking lot of the District B13 Boston Police Department station and flagged down Boston Police Department officers to report that a local grocery store was illegally putting pesticides and other substances in its meat. Maybe not the grocery store, maybe, our companies that make them, but according to the BP, I'm saying he's not probably far off from thinking that there are things inside the food that we shouldn't be eating. According to the Boston Police Department incident report, Mr. Root claimed that he worked or formerly worked for the CIA, the DEA, and NASA. Boston Police Department officers ran Mr. Root's license plate, which was the same plate that was on his car on February 7th, 2020, and learned that his vehicle was registered to Justin Root. As a result of a frisk of Mr. Root and a search of his car, the Boston Police Department learned that Mr. Root possessed a clear plastic paintball pistol and a BB gun pistol. Because of this incident, Mr. Root was FOIA'd, meaning that the information the BPD learned as a result of the incident was added to the BPD's field interrogation and observation database. So he was FOI'd, however you want to pronounce that as an acronym. I don't know. Boston Police Department officers shot Mr. Root near 75 Fenwood Road. On the morning of February 7th, 2020, Mr. Root drove his light gray Chevy Volt with a Massachusetts license plate from his residence in Mattapan to Fenwood Road in Boston. He drove past the Massachusetts Mental Health Center at 75 Fenwood Road and double parked his car in front of 65 Fenwood Road. This location is 1 block from the main entrance to Brigham and Women's Hospital located at 75th Francis Street in Boston. Upon information and belief, around this time, the Boston Police Department was called with a report of a person with a gun near Brigham and Women's Hospital. According to Defendant Officer McMenamy, who heard a Boston Police Department dispatch report of the incident over his radio, calls for people displaying guns is very common in that area. He did not respond to the call. Ultimately, two other BPD officers, Defendant Officer Godin and Officer Michael St. Peter, arrived on the scene in separate marked BPD cruisers. Defendant Officer Godin drove to the Fenwood Road area and parked his cruiser in front of 65 Fenwood Road at the intersection of Fenwood Road and Vining Street and in very close proximity to Mr. Root's vehicle. As Defendant Officer Golden was exiting his vehicle, Mr. Root was walking down Vining Street, away from Francis Street, and towards Fenwood Road. As Defendant Officer Golden turned the corner on the sidewalk from Fenwood Road onto Vining Street, he encountered Mr. Root. Upon seeing Mr. Root, and while Mr. Root was facing away from him, Defendant Golden drew his firearm. So, without needing, there was no real reason to stop him with a firearm. You didn't need to. You could have just asked who he was, what was going, assess the situation a little better instead of just pulling your gun out and pointing it at him and barely giving him time to say boo before you shoot him. I mean, that's pretty much what happened. So here is a picture. You can see Officer Godin's police cruiser right there. This is Godin here, and you can see Root, who wasn't even facing Godin. And Officer Root came around the corner and then drew his gun at Root. So he kind of unseemingly approached Root and probably scared Justin more than anything else. When Mr. Root turned around and saw Defendant Officer Godin's gun pointing in his direction, Mr. Root removed from his waistband and an uncharged, unloaded clear plastic paintball gun. So you could see he's already reaching for his gun before Root is even looking in his direction. His head is facing that way, so he's not even he turns around, and this is according to video. He turns around and Officer Godin's gun is already drawn at him. Defendant Officer Godin fired at Mr. Isn't this different? Isn't this completely different than what the officers' reports and everything and the DA's reports are explaining? The way that the family's laying it out, it just seems once both stories can't be true, right? So, and now that the family has been getting more and more discovery in this case, they were able to put more of the pieces together a few months later. All right, so Mr. Root removed after seeing the gun pointing at him. Mr. Root removed his the gun from his waistband. Defendant Officer Godin fired at Mr. Root and then stumbled backward and fell onto the sidewalk and into the intersection. How embarrassing! And he should be embarrassed. You fired on him. You pointed your gun at someone who may or may not have even been a suspect, and then you shoot them and stumble and fall. And it's all on video. And your story you've been lying about ever since. And all the Boston police officers are lying for you to cover for you as well. So that's pretty sad. So Officer Godin then, according to him, got to his feet and attempted again to fire at Mr. Root, but his firearm jammed. Upon information and belief, defendant Officer Godin's BPD issued firearm is a Glock 22 with a serial number of VYN765. In violation of BPD policy, the firearm defendant Officer Godin used on February 7th was not his BPD assigned Glock, but instead was a firearm on which he has not been qualified. Remember, they said that they somehow switched the keys, somehow unlocked multiple lock boxes or lockers, and him and another officer switched firearms that day or something. I don't know. That's the reason the Boston police gave. According to the defendant, Officer Godin, he does not know how he came to be without his BPD issued firearm. I don't know how I got it, officer. During an interview conducted as part of the Norfolk County District Attorney's Office investigation into the events of February 7th, defendant Officer Godin could not remember the make or caliber of his firearm. At one point, he said it was a Glock 22. When asked the caliber, he said a 45, but was corrected by an investigating officer who informed him it was a 40 caliber. He then agreed that it was a 40 caliber and stated without being asked that it was a 40 caliber Smith. And finally, an interviewing officer again corrected him and explained that his BPD issued firearm was not a Smith but a Glock 22 40 caliber. So he didn't know the make or caliber of his gun. Moments before, so how do you get qualified on it? Like, how do you not know your own state issued weapon? I don't know. Moments before defendant Officer Godin parked his cruiser in front of 65 Fenwood Road, sorry, didn't mean to stop in the mid sentence, but it made me think, unless he's purposely being dishonest about what gun was used, maybe something, um, maybe there was some kind of nefarious way as to how he got the other officer's gun, so he can't say he's being vague on purpose or something. I don't know. Anyways, all right. So moments before defendant Officer Godin parked his cruiser in front of 65 Fenwood Road, Officer St. Peter arrived and parked his cruiser in the middle of the intersection at Fenwood Road and Vining Street. According to Officer St. Peter, he exited his cruiser, stood by the hood of the driver's side, heard shots fired, and fired at Mr. Root. Officer St. Peter also stated that he saw Mr. Root fall and grimace, and that he believed that Mr. Root was mortally wounded and would succumb to his injuries at some point. So even before the 31 shots in Brookline, the incident in Boston, this officer, St. Peter, believed that Justin would probably succumb to those injuries. At no point during his interactions with the BPD officers that morning were paintballs or anything else fired from Mr. Root's uncharged, unloaded, clear plastic paintball pistol. At no point that morning was no paintballs or anything fired from Mr. Root's gun. It was a paintball gun, so I guess you have to charge it or something, if it works on batteries. I have no idea. So you charge it, it was uncharged, unloaded, nothing in it. So there was no ammo, no paintballs, no nothing. And it was a clear plastic paintball gun that was completely harmless. And it cost him his life, unfortunately, because these officers just don't know how to do their due diligence. Surveillance video footage shows that while defendant Officer Godin was getting to his feet and Officer St. Peter was standing next to his cruiser, Mr. Root limped back to his Chevrolet Volt, got into it, and drove away. So here's another image here. Actually have a series of images. So this first image is you can see defendant Officer David Godin stumbling off the curb. He's falling there. The defendant Officer Godin's cruiser is right here. You can see the lights. I'll highlight. You could see flashing lights and Godin's right there. Uh, St. Peter is here. Mr. Root's car is this one right here. Okay. So Mr. Root gets up. You can see him standing right there. And then he walks to his vehicle. And defendant Officer Godin and Officer St. Peter then got into their respective cruisers and began to pursue Mr. Root westbound on Route 9, or also known as Huntington Avenue, towards Brookline. Over the radio in his cruiser, defendant Officer Godin informed dispatch, "I've shot him. I know I shot him." Nothing like I've been shot. No, no, I've shot him. So he knew he shot Root, even though he wasn't shot. And yet they're still pursuing him, even though Officer Godin wasn't shot. See the problem? Upon information and belief, Mr. Root was not the only person whom BPD shot at in the near Brigham and Women's Hospital that morning. A valet standing near the entrance at the hospital at 75 Francis Street was struck in the head by a bullet shot by either defendant Godin or Officer St. Peter as they fired at Mr. Root. In one of the DA's reports, I want to say it was the Suffolk County report, I think they think it was Officer Godin who fired the stray bullet that went into the valet's eye and injured him. The Suffolk County District Attorney's Office confirmed the valet was shot by BPD and is investigating defendant Officer Godin's and Officer St. Peter's conduct on the morning of February 7th. That investigation is ongoing. This came out before the DA's report, though. So they, of course, said we didn't do anything wrong. Individual defendants fatally shot Mr. Root on Route 9 in Chestnut Hill. As defendant Officer Godin and Officer St. Peter chased Mr. Root westbound on Route 9, other BPD cruisers joined the pursuit. Again, he did nothing wrong. He didn't shoot anybody. He hasn't done anything. He got shot by a bunch of rogue police officers and got in his vehicle and left. And now they're pursuing him for what? Leaving the scene after being shot by police officers? Is that a crime? I guess. I don't know. All right. So among the BPD officers who joined the pursuit were defendants officers Figueroa, Thomas, McMenemy, and Fernandez. Defendants officers Thomas and Fernandez were together in the same cruiser. So Thomas and Fernandez, they were partners. According to defendant Officer Godin, during the pursuit, he was able to fix the jam in the firearm that he was carrying. So remember, it jammed when he was on the ground, and apparently driving, he was able to fix it and call the station and say, "I shot him, I shot him." According to the Norfolk County District Attorney's Office, near the beginning of the pursuit, a Boston police cruiser struck Mr. Root's vehicle in an unsuccessful attempt to disable or stop it. Defendant Officer McMenemy was the officer who tried to pit maneuver Mr. Root on the driver's side of his car. A pit pursuit intervention technique is a maneuver technique whereby an officer deliberately strikes or makes contact with a vehicle being pursued to bring it to a stop. So you've seen it in all the car chases. The cop comes and hits him in the corner. Oh, you can't see my hand. So like one car's here, and then the cop hits him in the back and it goes out of control. That's what happened here. But in his interview, he said, "I tried to pit maneuver." Like he didn't succeed or something. No, you did. You did conduct a pit maneuver on Root, um, which is an illegal act, by the way. It's not approved of by policy, BPD policy. On video footage taken on February 7th, defendant Officer McMenemy is recorded saying, "I rammed him on Huntington. Like everybody was kind of following him, so I came in and I just boom while making a tea with his hands." It sounds to me like these guys are in a movie pursuing, they think some nefarious drug kingpin or something, like, they don't even know what the situation is and they're just chasing this guy that they shot, and they're still pursuing him like he's a criminal. Using a police vehicle to deliberately strike a pursued vehicle violates BPD rules and procedures. And they provided a link of the procedures. Vehicle contact: officers shall not use police vehicle to deliberately make contact with a pursued vehicle, from their guidelines. The extent to which Mr. Root's vehicle was damaged and made less operable by defendant Officer McMenemy's reckless behavior is uncertain. Similarly uncertain is the extent to which Mr. Root suffered further injury as a result of that collision. Yeah, you also could have injured Root more after injuring him for no reason the first time. After defendant Officer McMenemy struck Mr. Root's car, Mr. Root put his Chevrolet Volt back in motion and continued driving westbound to Route 9 into Brookline, with 6 to 7 BPD cruisers still in pursuit. In addition to in addition to prohibiting pit maneuvers, BPD rules and procedures relating to pursuit driving require that supervisors be engaged to control and coordinate the pursuit and to provide supervision, support, and guidance to pursuing officers during and after the pursuit. I'm willing to bet there was no supervising officer here if they're pointing this out. As evidenced by, among other things, defendant Officer McMenemy's pit maneuver, BPD failed to maintain proper supervision over the pursuit. So who was in charge? No, we don't know. Nobody from BPD was, because when they got to the other scene, the Brookline scene, the trooper took control. Trooper Keneally was in control for some reason. I don't know. Massachusetts State Police cruisers also joined the pursuit. Among the state police troopers who joined the defendant, Trooper Keneally was defendant Trooper Keneally was on patrol on Route 9 near Brooklyn Newton line when he learned that shots had been fired in the vicinity of the hospital, and the BPD officers were pursuing a suspect in a vehicle traveling westbound on Route 9. He headed eastbound on Route 9 in the direction of the hospital. He stopped his cruiser in a cutout in the median of Route 9 and planned to put out stop sticks stop sticks, a tire deflation device, to stop the suspect's vehicle. Before defendant Trooper Keneally could put out the stop sticks, Mr. Root in the identified vehicle had passed him. Defendant Trooper Keneally then fell in line behind several BPD officers in pursuit. During the drive westbound on Route 9 from the hospital, Mr. Root was bleeding profusely. We know this from the um what are the words I'm looking for? We know this due to the condition of his vehicle, and trigger warning, there are going to be some images of his vehicle with blood. So just be aware, it's coming up as soon as I bring this page up some more. All right, so there was evidence that he was bleeding profusely from a gunshot wound that he sustained back at the hospital. A Fallon ambulance report prepared later that day reflected that Mr. Root had lost approximately 2,000 cc's of blood. That's almost half of the total amount of an average size adult while he was in his car. So he lost almost half of his blood while in the car chase. So think about that. He was injured by these officers for doing nothing wrong, and then uh he's bleeding out in his car as they're still trying to crash into him, trying to stop him, and using more force and violence against him. The following photos show the blood pooled on and soaked into the driver's seat and surrounding areas of Mr. Root's vehicle. Also shown is the uncharged, unloaded, clear plastic paintball pistol that had been carried by Mr. Root on Vining Street. You can't. We'll get better pictures of the gun. So here's the gun. You can see. I'll circle it or outline it, I guess. Yeah. So there's the clear plastic gun. You can tell it's not a real gun. You can tell it's a toy. It's a close up of it. See more blood. Approximately 6 minutes after being shot in Boston and leaving 65 Fenwood Road, Mr. Root's Chevrolet Bolt collided with another vehicle at the intersection of Route 9 and Hammond Street in the Chestnut Hill neighborhood of Brookline. His car continued through the intersection and came to a stop in the right-hand lane of Route 9, which was near the entrance to a shopping center parking lot. Mr. Root's car was severely damaged. By the time the vehicle came to a stop, three of its tires had fallen off. And I'd like to think that maybe that pit maneuver might have something to do with that. Here's an image of his vehicle after its final collision. Here's the other side. See that wheel's hanging, barely hanging on. This is the only wheel still intact. This one's missing. That one's missing. That one's not attached. Defendant Trooper Keneally saw the collision and observed Mr. Root's car travel through the intersection, collide with another car, and come to a stop on the opposite side of the intersection. Seconds after coming to a stop, Mr. Root opened the driver's door and began to exit his vehicle. As he was getting out of his car, he fell, got up, stumbled around the front of the car, and limped onto the nearby sidewalk. There, his legs buckled and he fell onto his back. He continued to lie on his back for a moment, but eventually managed to get himself back on his feet. At the moment Mr. Root's vehicle came to a stop, a female former emergency medical technician, the EMT, was sitting in her car in the adjacent shopping center parking lot. The EMT saw Mr. Root's car strike the curb and come to a stop. She observed him get out of his car and then fall onto the sidewalk. As she later explained to law enforcement investigators, when she saw Root fall and struggle to get back up, she realized something was really wrong. She realized something was wrong. These officers couldn't figure it out. She saw him for 1 second and realized something was really wrong. And then she went running towards him to administer aid. Mr. Root staggered from the sidewalk into an adjoining mulched area with trees and shrubbery. As the EMT further explained to law enforcement investigators, when she reached Mr. Root in the mulched area, he had fallen again and was trying to stand back up again, but he was very, very wobbly. He was clutching his chest, and she thought that he was having a heart attack. As she was standing over him, she saw that he was covered in blood. He was not talking or groaning, and the former EMT described him as having lights on, no one home, meaning he wasn't necessarily comprehending what was happening in the moment. The EMT was trying to render aid to Mr. Root, who, in her opinion, appeared unable to communicate. As she put her hand on his left shoulder to assist him, she heard a police officer ordering her to run away. Imagine that. She's offering aid, medical assistance to someone in severe need of it, and she's ordered to run away by the police. Reluctantly, she did so. As she described to law enforcement, she heard screaming, "Run, run, run, go," and she turned around and there was what seemed like at least a dozen officers with their weapons drawn, pistols, and it looked like, or handgun shotguns. So they all just already had their guns out. There was no, again, no assessing the situation. The following stills from a video captured by a bystander's cell phone show the EMT approaching Mr. Root to help him as he fell to the ground. Um, this was reported in the police the police reports that there was a bystander with a cell phone and they were ordered to get back. But before they did, or maybe they have a really good zoom in on their phone, not the best quality, but you can see former EMT who tried to help Root is standing here, and Mr. Root is crouched down, and here he is on the ground. She's trying to stand over him and help him. Defendant Officer McMenamy was the first officer to arrive at the scene. As he entered the mulched area, he observed the EMT next to Mr. Root and touching his shoulder. He yelled at her to get away. Defendant Officer Godin arrived within seconds of Defendant Officer McMenamy. Defendant Officer Godin pulled his cruiser up past Mr. Root's car and saw Mr. Root lying on the ground. As he later described it to law enforcement investigators, he observed Mr. Root staggering up on that mulch area, not even staggering, almost like crawling. Staggering, crawling, not in an offensive position, right? So if he's staggering, struggling to walk, crawling, lying on the ground, whatever it may be, he's not on the offense, right? So why are we pretending like he is and just going in there guns blazing and shooting without asking any questions? I just don't get why this was allowed. He also saw the EMT trying to help Mr. Root. As the EMT began to run away, Defendant Officer McMenamy walked towards Mr. Root, and while standing directly over him as he was crouched on the ground and while in a position to observe Mr. Root's significantly impaired condition, Defendant Officer McMenamy put his foot up like at a 90-degree angle and kicked Mr. Root to the ground. Why? Just why? Defendant Officer McMenamy then stepped back and was joined by Defendant Officer Godin, Defendants Trooper Keneally, Figueroa, Fernandez, and Thomas, who formed a loose line, a few feet from Mr. Root. As the individual defendants charged into the mulch area, they collectively, simultaneously, and unintelligibly, I like that, began screaming a series of commands such as stay down, get down, and let me see your hands. So just a bunch of people yelling a bunch of stuff all at once, a bunch of commands all at once. A bystander who was in the parking lot reported to law enforcement that there were multiple cops yelling different things. So again, how are you coordinated? There was no coordination, there was no lead and sergeant or supervisor who was overseeing this. So everybody was just a free for all and yelling whatever they wanted to Justin on the ground. Another bystander stated that he could not hear exactly what the police were screaming because everybody was screaming. So I couldn't even hear it. They were all saying the same thing. So how could he know what they were saying? They were all screaming at the same time. Defendant Officer Godin admitted that he and the other officers yelled conflicting and confusing commands. So what are we doing here? Why are we not getting some kind of relief for the Root family? As he described it to law enforcement investigators, Mr. Root was it was in front of like a shopping plaza or a side mall or whatever, but he was up on the curb like a grassy, it was like all muddy and he was laying there. He laid there, and I'm just yelling at him to lay on the ground with your hands out. Get on the ground because he's in like a seated position. Actually, he was leaning to his right side on a seated position, and we continued to yell to tell him to lay on the ground, hands out. Everybody was yelling. Everybody. It was so loud, and there were so many of us just yelling commands. So even they don't know what was being said, they were all yelling different things. Even they admitted. Although the officers were screaming incomprehensibly, to get down and stay down, Mr. Root was already down on the ground, right? You're yelling at him to get down, but he's not up. How much further down do you need him to go? He's already incapacitated. Moreover, as the individual defendants plainly observed from a few feet away, Mr. Root was in no condition to comprehend, let alone respond to, the cacophony of orders being simultaneously shouted. He was helpless and incapacitated as a result of the tremendous loss of blood from the gunshot wound that he had suffered a few minutes earlier back at Brigham and Women's Hospital, a serious wound that both individual defendant Godin and Officer St. Peter had radioed to all that they believed Root had sustained. So it wasn't a secret. These people knew that they had shot him. They knew he was already injured, and yet they still did the pit maneuver. And when they get upon him, they start screaming and yelling, get down, show your hands, even though they already know they shot him and injured him. And they're not shot, which is an even bigger key to that. They thought that they were shot, that he was going to shoot them, and he didn't even have a gun. Finally, as each of the individual defendants acknowledged in post event statements to law enforcement investigators, at no time in Chestnut Hill did any of them see Mr. Root point or brandish a gun or any other type of weapon at them or anyone else. I'm going to repeat that. At no time in Chestnut Hill did any of them see Mr. Root point or brandish a gun or any other weapon at them or anyone else. Yet 31 shots. Why? Regardless, in a matter of a few seconds after defendant Officer McMenemy had kicked Mr. Root fully to the ground, and after the officers collectively and simultaneously shouted a host of incomprehensible commands without warning, the individual defendants opened fire from a few feet away and shot Mr. Root at least 31 times. All 31 shots were fired within approximately 3 seconds. At the time that the 31 shots were precipitously fired, Mr. Root posed no immediate threat, and many alternatives short of the use of lethal force remained available to the individual defendants. Clearly, a more measured approach was called for. They didn't have to go in there and just shoot him 31 times. There were other things they could have done to de escalate the situation. And every step they took escalated it, it seems. No one, including none of the individual defendants, took control of the scene before Mr. Root was shot. No one suggested that officers take cover or triangulate as they approached Mr. Root lying in the mulch. No one attempted to assess Mr. Root's physical and mental condition. No one attempted to engage Mr. Root in a conversation. Like, no one even tried talking to the guy. You just shot him. No one attempted to take a measured approach and de-escalate the situation. There was no one in charge. It was chaos. Tactically, it was a disaster, which is why they're trying so hard to bury it and be like, "Oh no, we didn't do anything wrong," because they know this is horrific. And this was all before Karen Reed, all before Sandra Birchmore. This was the garbage that apparently Suffolk County and Norfolk County were doing back then. Didn't change much since. They didn't think that this was going to get any attention. Instead, without any threatening action having been taken by Mr. Root within less than 10 seconds of the EMT leaving his side, and with what can only be described as a callous disregard for Mr. Root's life, the individual defendants collectively fired dozens of shots into Mr. Root. A total of 31 shell casings, all of which were matched to their firearms, were found at the scene. I hate interrupting constantly, but just imagine if a civilian shot someone 31 times without, you know, any kind of regard for human life. They'd be on like death row probably, or, life without the possibility of parole they'd be probably facing. Yet these cops did it in broad daylight and they get away with it. Just saying. Mr. Root's body was riddled with bullets and covered in blood. A witness informed law enforcement investigators that the shooting sounded like the 4th of July. The witness highly doubted that Mr. Root was moving after the shooting or that anyone could have moved after being shot like that because there was a lot of shots fired. That's a quote. After the shooting, Defendant Trooper Keneally and Defendant Officer Figueroa handcuffed Mr. Root. A BB gun pistol, which Mr. Root sometimes carried in a left shoulder holster, was reportedly found in the mulch under his body. So maybe this is his BB gun, but we know that he had the clear plastic gun on him in the videos. So where'd the BB gun come from? Was it in his car and they planted it as to say, oh, it looked like a real gun? Guys, come on now. We saw the clear plastic gun in the video from the hospital. Someone's lying, and it's not the Root family. Video footage captured law enforcement officers' conversations and conduct after the shooting. While Mr. Root was still lying in the mulch, Defendant Trooper Keneally walked over to Defendant Officer McMenemy and asked if he had fired shots. Defendant Officer McMenemy confirmed that he had. The two shook hands in a congratulatory manner. That's disgusting. Defendant Trooper Keneally reached out to shake another BPD officer's hand while asking if that officer had shot too. When that officer said he had not, Defendant Trooper Keneally withdrew his hand. I only give my handshakes to the troopers who kill innocent people for fun. Defendant Trooper Keneally then told Defendant Officer McMenemy, just shut your effing mouth and asked him, "You got a union rep or you got a rep coming?" Defendant Officer McMenemy responded, "Yeah, I don't know. I won't talk." Defendant Officer Godin told other officers, "I gotta get out of here." When an officer later asked Defendant Officer Godin if he was all right, he responded, "Yeah, I killed that MFer." Defendant Officer Godin also told a supervising officer at the scene moments after the shooting, "I emptied my magazine on him." While walking around the scene after the shooting, Defendant Officer Figueroa asked another officer, "Did you shoot?" "I shot too. We're good." A male BPD officer in a gray hooded sweatshirt responded, "Don't say anything to nobody." It's funny how none of these comments came up in the DA's reports, right? About their own officers. Funny how that works. They must have missed this key piece of video evidence. The Root family didn't. None of the individual defendants attempted to administer aid or tried to revive Mr. Root. When one officer asked if someone wanted to check for Mr. Root's pulse, another responded, "Don't think he has one." A few minutes went by before officers began tending to him. The entire pursuit from its inception on Fenwood Road to where Mr. Root got out of his car on Route 9 lasted approximately 6 minutes. During that time, BPD officers, including Defendant Officer Godin, communicated over radio about the status of the pursuit. None of the officers and no BPD supervisor, however, formulated or communicated a plan for the pursuit itself or any confrontation with Root following the pursuit, right? There's got to be a leader. This is how, the military and police departments work. This paramilitary type mentality. Someone's the person in charge and everybody reports to them, and that person, you know, gives the orders and prepares his people for what to do in the event that this or that happens. You're prepared. But that didn't happen here. The individual defendants and the officers involved in the pursuit and the shooting were acting independently and without regard for how each other was approaching the pursuit, Mr. Root's apprehension, or the shooting. The individual defendants were unaware of which officers arrived on the scene on Route 9. They were unaware of where other officers were standing and were unaware of who shot at Mr. Root. So, in their interviews, none of them even knew who was standing next to them. Like, you should know your situational awareness. Like, Officer Figueroa was to my left, right, whatever, like you should know those things, and they didn't have those pieces of uh, evidence. They couldn't tell you from memory who they were standing by. For example, defendant Trooper Keneally admitted that other than an officer to his left, he had no idea if other officers around him were shooting too. Mr. Root's fatal injuries. Mr. Root was taken to the hospital by ambulance. He was pronounced dead at Beth Israel Deaconess Medical Center. The Massachusetts office of the chief medical examiner performed an autopsy on Mr. Root's body. The medical examiner's summary autopsy report reflects that there was a total of 50 gunshot wounds or bullet holes in Mr. Root's body, 26 of which were deemed entry wounds, and 26 of which were wounds to his torso, 22 of which were wounds to his torso. So 26 were entry wounds, 50 wounds altogether. Geez. He also had 6 bullet holes in his right leg, 5 in his left leg, 8 in his left arm and elbow, and a through and through hole in a right finger, and a through and through hole in his left thumb, and a graze wound on the left side of his chest. Mr. Root suffered brain hemorrhaging due to projectile that hit his vertebrae. So a projectile or bullet hit his vertebrae, resulted in a sudden rush of blood from his aorta to his brain. So when he was struggling, and when the EMT says he was lights on, no one home, he was already suffering, most likely from some kind of brain hemorrhaging and injury to his vertebrae before uh, the next 31 shots that were fired at him. The medical examiner determined that the cause and manner of Mr. Root's death were homicide by multiple gunshots from law enforcement. Defendants Officer Godin, McMenamy, Thomas, Fernandez did not have their body cameras turned on during the shooting. That's a problem. All BPD police officers, including the 5 BPD officer defendants in this case, are assigned BPD issued body worn cameras. By rule, BPD requires its officers to wear their body worn cameras when on duty and performing patrol function. That is the rule. That's required. Yet none of them had their body worn cameras on that day. BPD Rule 405 also requires BPD officers to activate their body worn cameras during all dispatched calls for service, including contact with civilians, incidents of pursuit driving, so they should have had it on during their car chase, any contact that becomes adversarial, including a use of force incident like this, when the officer has not already activated the body worn camera, and any other civilian contact or official duty that the officer reasonably believes should be recorded to enhance policing transparency, increase public trust, yeah, right, and police community relations, or preserve factual representations. Just, put it on the record of officer civilian interactions, providing that recording complies with other sections of the BPD body worn camera policy. So basically, any interaction you're having when you're on duty, if you're in a pursuit, you should have your camera on and rolling. Why all these officers did not? Big mystery. All 5 of the BPD officer defendants have had been issued body worn cameras. Contrary to BPD Rule 405, only defendant officer Figueroa activated her body worn camera before the shooting. So out of 5 officers, one of them followed the rule. Now we see part of the problem here, right? Although she did not activate her body worn camera at the outset of the pursuit, she did while she was pulling up to the area where Mr. Root got out of his car on Route 9. Defendant Officer Figueroa, however, wore her body worn camera in such a way that her camera was largely covered when she approached and shot Mr. Root. She turned her camera off approximately 5 minutes after the shooting. So her camera, basically, you see nothing but black because her arm is in the way. So it's largely covered. Camera's largely covered. Both defendant Officer McMenamy and Thomas were wearing a body worn camera during the shooting, but neither activated it until after the shooting. A lot of good it does you then. Defendant Officer Godin and Fernandez reported to law enforcement after the shooting that they were not wearing their body worn cameras at the time of the shooting. That we've talked about a little bit more, where defendant Godin actually had it on him, took it off of him, and put it in his vehicle. So there's that. He took it off of him, put it into it, threw it kind of, or tossed it into his vehicle right before pursuing Root at the Brookline scene. All right, so that's basically the complaint. We've got counts. So these would be like excessive force of ex- excessive use of force in violation of Justin Root's Fourth Amendments. Um, I'm not going to read everything here. Just basically that they while the defendants were acting under the color of law, and using their force as law enforcement, they were intentionally restraining Mr. Root's freedom and movement and ability to walk by pointing their firearms at him and issuing verbal commands. First, he didn't do anything wrong, so why? Their conduct constituted a seizure within the meaning of the Fourth Amendment. The individual defendant's shooting of Mr. Root while acting under the color of law was intentional. The defendants drew their firearms, pointed their firearms at Mr. Root, placed their fingers on their triggers, fired their firearms by intentionally applying pressure to the triggers, and intended to shoot Mr. Root and cause him severe physical injury or death. As a result of the individual defendant's actions, Mr. Root was seized within the meaning of the Fourth Amendment. When the individual defendants shoot Mr. Root, he was in their custody and control. So when they shot him, he was illegally in their custody for no reason. Moments before the shooting, the EMT was able to readily recognize that Mr. Root was seriously injured and needed immediate medical attention, so she tried to help him. He had fallen on the sidewalk. He staggered into the mulch area, was unable to get up, was severely injured, and was covered in blood, was non communicative, was grasping his chest, and appeared to be having a heart attack. At the time of the shooting, Mr. Root was defenseless and unarmed. He did not flee, he did not resist in any way, and he did not pose an immediate or future threat of harm to the individual defendants or anyone else. As a result, the individual defendants had no reasonable justification for their use of deadly force. The EMT didn't think that she was in fear. She was more afraid of the cops who were pointing guns in her direction than anything else. She wasn't afraid of Root. She knew Root was in needing help. She was medically um, having a medical emergency. The individual defendant's intentional use of deadly force was unreasonable, excessive, unjustified, and constitutes a seizure under the Fourth Amendment. The individual defendants violated Root's constitutionally protected right under the Fourth Amendment to be free from reasonable seizure of his person. So he didn't need to be, there's a constitutional right to not be illegally seized by your government, which is what happened here. As a direct and proximate result of the individual defendant's intentional conduct, Mr. Root was subjected to excessive force during a seizure and was killed. An objectively reasonable law enforcement officer would have understood at the moment that the shots were fired that employing deadly force against Mr. Root under the circumstances would contravene clearly established case law and general Fourth Amendment principles and statements of law. The defendant's intentional and excessive use of force was such an obvious and or apparent violation of the Fourth Amendment's prohibition against unreasonable seizures that a reasonable officer would not have required prior case law to be on notice that his or her conduct was unlawful or unconstitutional. Like any cop would know that what you did here is wrong. A reasonable officer in the defendant's position would or should have understood that his or her conduct violated Root's right to be free from excessive use of force, of deadly force. Plaintiff is therefore entitled to damages and attorney's fees. Count 2, excessive use of force against the individual defendants. Plaintiff realleges everything above. During the shooting in Chestnut Hill, the individual defendants, by means of threats, intimidation, and coercion, intentionally and unlawfully used excessive deadly force against Mr. Root, and therefore interfered with Mr. Root's right to be free from unreasonable seizures secured by Constitution. Mr. Root was killed as a result of the individual defendant's use of threats, intimidation, and coercion to interfere with his rights. Plaintiff is therefore entitled to damages. Deprivation of due process in violation of Justin Root's 14th Amendment rights. 14th Amendment protects a person from the deprivation of life, liberty, and property without due process of law. The individual defendant's conduct described above was committed under color of law and reflects reckless or callous indifference to Mr. Root's clearly established rights in violation of Mr. Root's 14th Amendment right to life. As a direct and proximate result of the individual defendant's reckless or callous indifference, Mr. Root was deprived of his life. So basically, because they were just so callous and indifferent about another human being, he didn't get due process, and because of that, he lost his life, which is the ultimate loss. The individual defendant's violation of Mr. Root's 14th Amendment rights through their reckless and callous conduct was clearly established under existing case law or general 14th Amendment principles and statements of law, such as it was apparent to the defendants that their conduct was unlawful and constitutional. The defendant's violation of Mr. Root's 14th Amendment rights through their reckless and callous conduct was such an obvious and or apparent violation of the 14th Amendment's general prohibition of the deprivation of life without due process of law that a reasonable officer would not have required prior case law to be on notice that his or her conduct was unlawful and unconstitutional. A reasonable officer in the individual defendant's position would or should have understood that his or her conduct violated Root's rights to due process. Plaintiff is entitled to damages. Count 4, due process. During the shooting in Chestnut Hill, the individual defendants, by means of threats, intimidation, and coercion, intentionally and unlawfully used deadly force against Mr. Root and thereby interfered with Mr. Root's right to life secured by Article, what is that, 7 of the, no, 12 of the Massachusetts Declaration of Rights and by the 14th Amendment of the United States Constitution. Mr. Root was killed as a result of the individual defendant's use of threats, intimidation, and coercion to interfere with his rights. Plaintiff is entitled to damages. Count 5, excessive use of force in violation of Justin's Fourth Amendment rights. During the vehicle pursuit of Mr. Root's car, defendant Officer McMenemy, acting under color of law, intentionally restrained Mr. Root's freedom of movement and used excessive force against Mr. Root by engaging in a pit maneuver and colliding with Mr. Root's vehicle. Mr. Root was thereby seized within the meaning of the Fourth Amendment. A pit maneuver is an unreasonable and dangerous, very dangerous technique by which an officer uses his moving vehicle to stop a suspect's moving vehicle. And in the process, Root sped up, hit I want to say three other vehicles, and those other people may have sustained injuries. And all of that was because this officer, McMenemy, acted against BPD policy and decided that he was going to try a pit maneuver. Defendant Officer McMenemy intentionally performed a pit maneuver by using his BPD cruiser. BPD recognizes that a pit maneuver is unreasonably dangerous. The BPD policies and procedures expressly prohibit the use of pit maneuvers. When defendant Officer McMenemy first approached the scene of the ultimate shooting, he observed the EMT attempting to render aid to Mr. Root. He ordered the EMT to get away from Mr. Root. Mr. Root was defenseless, not armed, offered no assistance, did not attempt to flee, and offered no resistance, did not attempt to flee, and posed no immediate threat of harm to the defendants or anyone else. Root was defenseless. He was not any kind of threat to anyone. He was severely injured, bleeding profusely, nonverbal, and appeared to be having a heart attack. And this dude, McMenemy, was so close he could kick him, because he did. And he could not tell that there was something wrong with Justin? This EMT knew within seconds of seeing him. I mean, law enforcement is also supposed to be trained in life-saving measures. So he should know, he should have noticed the signs that Justin was unresponsive and not in a state where you should be giving him commands and pointing your gun at him. But anyways, he appeared to the EMT to not understand what was happening. As she stated to investigators, it appears that the lights were on, but no one was home. As the EMT obeyed Defendant Officer McMenemy's orders to get away, Defendant Officer McMenemy approached Mr. Root, who was crouched on the ground, and intentionally kicked him to the ground, exacerbating his already seriously complicated condition. So not only did you do this pit maneuver, which potentially caused more injury to Root and definitely caused damage to to property and people's property and their vehicles and potentially other people. Um, Now you're kicking him too. Got it. We know what type of person McMenemy is. Joseph McMenemy, Boston PD, is the type of guy that will kick you when you're down, apparently. So he approached him, who was crouched on the ground, and intentionally kicked him to the ground, exacerbating his conditions. Defendant McMenemy's intentional use of force in executing the pit maneuver and in kicking Root were both excessive and unjustified. Defendant McMenemy violated Mr. Root's right under the Fourth Amendment to be free from unreasonable seizures of his person. I think if anyone should be sued out of, well, Godin especially, but also McMenemy, because he caused the pit maneuver and he kicked him, and he's part of the problem of trying to continually restrain and cause dangerous actions in the public to restrain this person who he thinks is such a danger, when really the people that are dangerous to society right now are the police officers. Okay, sorry, I had to get that out. So, kicking him was both excessive and unjustified. Defendant Officer McMenemy violated his rights under the Fourth Amendment to be free from unreasonable seizure of his person. As a direct and proximate cause of Defendant McMenemy's intentional conduct, Mr. Root was subjected to excessive force during the seizures. Defendant Officer McMenemy's violations of Mr. Root's Fourth Amendment right, though through his use of force, were clearly established under existing case law or general Fourth Amendment principles and statements of law, such as it is apparent to Defendant Officer McMenemy that his conduct was unlawful and unconstitutional. McMenemy's intentional and excessive uses of force were such obvious and/or apparent violations of the Fourth Amendment's prohibition against unreasonable seizures that a reasonable officer would not have required prior case law to be on notice that his conduct was unlawful. A reasonable officer in Defendant McMenemy's position would or should have understood that his conduct violated Root's right to be free from excessive use of force. Plaintiff is entitled to damages. Uh, Again, excessive use of force, count 6. Yeah, we're on count 6. Plaintiff realleges everything above. When Defendant Officer McMenemy performed a pit maneuver during the vehicle pursuit, Defendant Officer McMenemy, by means of threats, intimidation, coercion, intentionally and unlawfully used excessive force against Mr. Root and thereby interfered with Mr. Root's right to be free from unreasonable seizures secured by Article whatever we're at now of the Massachusetts Declaration of Rights and by the Fourth Amendment to the United States Constitution. When Defendant Officer McMenemy kicked Mr. Root, Defendant McMenemy, by means of threat, intimidation, and coercion, intentionally and unlawfully used excessive force against Mr. Root and thereby interfered with Mr. Root's right to be free from unreasonable seizures. Plaintiff is entitled to damages. Count 7. Negligent training and supervision. Plaintiff realleges all above. The City of Boston, through its agents, servants, and employees in the BPD, had the duty and responsibility for the training and supervision of the police officers regarding the appropriate use of force during a seizure and the appropriate methods and practices to avoid the use of deadly force upon a seized person, including those who do not pose an immediate risk of serious harm to others. On or before February 7th, 2020, the City of Boston's policymakers knew or should have known that their police officers had in the past and would in the future be faced with similar situations to the circumstances and facts alleged where police officers might be in a position to consider the use of deadly force on a suspect such as Mr. Root that A did not pose any immediate danger to police officers or others, B did not have a firearm, C was severely injured and covered in blood, and D lying on the ground. City of Boston, under color of law, failed to provide adequate training to its officers regarding procedures and methods to avoid the infliction of deadly force on a seized person who was already seriously injured, was defenseless, was not armed, did not resist the police, did not attempt to flee, and posed no immediate or future threat of harm. The procedures and methods as to which the City of Boston failed to provide adequate training include, but are not limited to the following: the proper and reasonable procedures for conducting a vehicle pursuit, the proper and reasonable procedures to ensure that a supervisor is in charge and properly coordinates, manages, and oversees a pursuit, which they did not have here. The proper and reasonable procedures for identifying and assessing a scene prior to restraining and making physical contact with a suspect. This is what I've been saying from the beginning. They didn't assess the situation. They just went in there guns out. And it really says something. And then at the end, when they're just congratulating themselves on video, that pretty much tells you the mentality of these officers where they're just like, I don't care who I shoot, I'm just gonna shoot. Proper reasonable procedures for the safe and proper restraint of a suspect without causing him great bodily harm. Oh, I think I skipped one. Proper procedures for identifying and assessing a scene prior to restraining and making physical contact with a suspect. Oh, no, I didn't. I did read that one. Assess the situation. Assess the situation before you just go shooting. The proper and reasonable procedures to be followed when approaching a suspect they believe to be armed. The proper and reasonable procedures for taking control of an arrest scene involving multiple law enforcement officers and ensuring that one officer serves as the primary officer or supervisor. The proper and reasonable procedures to be followed with respect to of to the use of less than lethal force. So why was everybody just ready to use lethal force immediately? There's no training on using being restrained in your responses and not killing the person. Do they just try to kill everybody that they interact with? I mean, there has to be some kind of training to keep them from using force, unnecessary, needless force. The proper and reasonable procedures to be followed with respect to the use of lethal force. See, proper and reasonable procedures for de escalation prior to the use of lethal force, including without limitation the need to assess the suspect's physical and mental condition. Yeah. Well, and also, don't you have tasers? You didn't have to shoot him with your gun. The proper and reasonable procedures to be followed by an officer in preparing to fire his or her weapon. The proper and reasonable procedures to be followed to avoid contagious fire. Contagious fire, like one officer shoots and hears shooting, so the other officer shoots, which is exactly what happened in this case, both scenes. The proper and reasonable procedures to be followed to ensure that medical assistance is provided to a suspect following the use of lethal force. and the proper and reasonable procedures to be followed with respect to the use of issued body worn cameras, including but without limitation when they should be worn, activated, and deactivated. Proper training in one or more of the procedures listed in the above paragraph would have prevented the shooting of Mr. Root in Chestnut Hill and could and should have been implemented by the City of Boston. The BPD defendants could and should have been trained in those procedures. So that's why Boston, the City of Boston, is being sued because they have a duty and a responsibility to train their officers to properly respond to these situations and to not use deadly force. So that's why they're being brought in on this lawsuit. Mr. Root's death was caused by the City of Boston's policy or custom of inadequate training and supervision of its police officers, including the BPD defendants, the City of Boston's failure to provide adequate policies and procedures, and/or City of Boston's failure to ensure compliance with its existing policies and procedures. City of Boston's custom of inadequate training and supervision of its police officers amounts to deliberate indifference to clearly established constitutional rights of others, including Mr. Root, to be free from the use of excessive force and deprivation of his life without due process of law. The reckless or negligent manner in which the City of Boston trained and supervised its officers failed to provide necessary policies and procedures and/or failed to enforce existing policies and procedures created a high risk of death to others, including Mr. Root. So they had some policies in place, like don't do pit maneuvers, and those procedures weren't followed. And then they had other other things that occurred where policies weren't even in place for certain things that should have been. So it's kind of twofold there. They should have had policies for certain things, and some policies that were already in place were just deliberately not followed. Simple as that. Policymakers for the City of Boston knew to a moral certainty that their police officers, including the BPD individual defendants, would be required to encounter and seize individuals, including individuals that are physically or mentally impaired. The inadequacy of the City of Boston's policies and procedures, its compliance protocols, its training, and its supervision were so obvious and likely or probable to result in the violation of constitutional rights that the City of Boston's policymakers acted with deliberate indifference to the need to protect civilians. So your inadequacy to properly train your officers was so bad and it looks so deliberate. It's just a deliberate indifference because you haven't done anything to enforce the policies that you do have in place, and you're not making sure that your policies are up to code or up to date and effective. So you've got some problems here, Boston. City of Boston's policymakers acquiesced in and implicitly authorized the use of excessive force during a seizure. So basically, the City of Boston is complicit by not training your officers. So you're complicit in using lethal force. The City of Boston had acknowledged of an obvious risk to the constitutional rights of persons with whom the police would come into contact, and the City of Boston failed to act despite the obvious risk. The above alleged constitutional violations by the BPD individual defendants were approximately caused by the City of Boston's deliberate indifference to the training and supervision of those officers and by the City of Boston's decisions, policies, and procedures with respect to the use of force and avoiding deadly force during the seizure of a person. Plaintiff is entitled to damages. Just a few more here. Count number 8, assault and battery. The individual defendants intentionally and unjustifiably used deadly physical force against Mr. Root during the shooting in Chestnut Hill. The use of deadly physical force was unreasonable, offensive, unconsented to by Mr. Root, and resulted in the death of Mr. Root. Plaintiff is entitled to damages. Wrongful death, count 9. The individual defendant's shooting of Mr. Root in Chestnut Hill was intentional, willful, wanton, and/or reckless. It was, I believe, all of those things. Moments before the shooting, the EMT recognized Mr. Root was seriously injured and needed immediate medical attention, so she tried to help him. Among other things, he was covered in blood, had fallen on the sidewalk, was unable to communicate, and appeared to be having a heart attack. At the time of the shooting, Mr. Root was defenseless, was unarmed, offered no resistance, did not attempt to flee, and posed no immediate or future threat of harm to the individual defendants or anyone else. He was severely injured, bleeding profusely, nonverbal, and appeared to be having a heart attack. It appears that the lights were on, but no one was home. The individual defendants had intentionally seized Mr. Root, and despite his incapacitation, the individual defendants all opened fire on him. Mr. Root's death was a direct and proximate result of the individual defendant's unjustified conduct. In conclusion, the plaintiff respectfully requests that this court enter a judgment in plaintiff's favor in such amount as will fully compensate the estate for its losses to the greatest extent allowed by law, order such punitive damages as are allowed by law, order payment of interest, costs, and attorney's fees as allowed by law, and order such further relief as this court deems fair and just. The demand for a trial by jury is also asked. Plaintiff demands that the present case be tried before a jury, which it has not. It's been dropped or um, uh, basically ruled that in each of these cases, it's been ruled that the officers were acting in out of their duty and they didn't do anything wrong. They basically have immunity, and that's one of the things that I've been complaining about the most, and so it like frustrates me the most is this immunity that officers, law enforcement, prosecutors, judges all have, and it's ridiculous and it needs to stop. And I think a lot, if these people didn't have immunity, I think maybe our justice system would be a little more fair. Just saying, because they can get away with things, they do. And that's obvious in this case. It's obvious in the Karen Reed and Sandra Birchmore cases. And I guarantee they're not the only ones in Norfolk County, Suffolk County, and all over the United States. So this is not a rarity. It's just unfortunate that things like this have to happen in order for the corruption to really shine through, I guess. Um, because I've gone over this in the timeline episode that the family has struggled just to get a court to hear this, just to get a court to listen to these arguments and say, and not just look at it and be like, oh, the officers they're immune. So they were just acting out of, their regular duty and they couldn't have known. So whatever. No, no harm, no foul, basically, to them, not to the Root family, not to society as a whole, because when these things happen to our society, it damages us. It harms our ability to be free, our ability to have a free society. We're not in a free society anymore. And it's evident with all the cases that we're following now and seeing the corruption that's happening. So I don't know. Sorry to leave you kind of on a downer, but I feel like it's so frustrating to me after I started this channel. Like it really has gotten to me. Some of this has really hurt my soul just knowing that some of these things are happening and families aren't getting justice and victims aren't getting justice and innocent people are going to prison or getting persecuted by the full power of the state. And that's why we really need to talk about these things. So please make sure you share this video, subscribe, hit the like button, do all the YouTube things so that the algorithm picks up so that more people get interested in this content, because this is a very important case, as are, all the others in Massachusetts, and how the corruption is starting to come out. So please hit the like button, share, comment, and I will see you guys in the next one. Take care. Bye, guys.